Yes, my name is Arie van den Krans. I work as a intellectual property advisor for the Netherlands Patent Office. So next slide, please. Netherlands Patent Office, um, in Dutch Octrooicentrum Nederland, is part of the Netherlands Enterprise Agency. In Dutch is de Rijksdienst voor Ondernemend Nederland, RVO. And the Netherlands Patent Office is the instance in the Netherlands which registers and grants Dutch patents. So if you file a patent application with my colleagues in The Hague, it'll be granted if it fulfills all the requirements. And next to that, we educate the public on intellectual property in general and patents more specifically. And we do that independently, confidentially, and free of charge because we are a government body. And the photo that is shown, that's our view from our office on the ninth floor of the building in Beatrixlaan number 2 in The Hague. So next slide, please. This photo is taken from a different angle. If you come from the Hague train station, you take the south exit, then you can walk up to Beatrixlaan 2, and there you see this building. And the Netherlands Patent Office is on the 8th and the 9th floor. So next slide, please. So a little bit about RVO, or Netherlands Enterprise Agency. This is a government body which is involved in executing national programs, such as subsidies and other arrangements for entrepreneurs. So also part of the measures that were taken by the government to support entrepreneurs during the Corona crisis were executed by RVO. And the Netherlands Patent Office, well, we do not do in subsidies, but we are part of a national program for reinforcing the Dutch entrepreneurs using intellectual property. So if you want to find out more about subsidies, etc., don't hesitate and visit the RVO website. So next slide. Yes. So topics for today is IP strategy, IP information, services by the Netherlands Patent Office, a summary, and some contact details. This presentation was taken from slides that are used to inform and educate mainly startups and small medium enterprises. But it'll give you a nice overview of what we do and where our expertise lies. So the most important thing that we try to convey to the public is that you need to develop an IP strategy as an entrepreneur, which is really at the heart of your business strategy. Become aware of the role that IP plays in your day-to-day activities. IP determines your relationship with key partners, has great impact on your activities, your value propositions, customer relationships, cost structure, and also on your revenue streams. So our education is aimed at strengthening that awareness. So next slide, please. Now, as you may probably know from open innovation theories that were brought to us, I think about 20 years ago by Henry Chesbrough, IP or intellectual property is a vehicle for open innovation, especially talking about patents. So in the different stages of innovation, from ideation to development to commercialization, intellectual property plays various roles. For example, in the ideation phase, for example, as a startup company, you may have access to basic technology which is provided to you, for example, by CERN or Philips, TNO, ESA, and you may be given an opportunity to find new applications for this technology. And this usually goes via licenses on intellectual property of these institutions. At the same time, in this stage, you may already want to find partners, or you may want to acquire inspiration from what is to be found in patent literature. If you seek to endeavor into certain areas of technology. Once you have decided what you want to do with your ideas, and you start developing products or systems or services, IP may help you establish alliances, acquire maybe licenses, or find co-development partners. And basically, what you do is you seek to find if you have novelty for your own ideas to create your own IP portfolio, but as much as important as establishing your own IP, establish whether you have freedom to operate relative to the IP of other companies. And once you have developed your product or service or system, you enter commercialization stage, and there you can find that the IP that arose from the development enables you to perhaps license out your technology and generate additional revenue streams. And in this stage, you want to monitor competitors to see if other parties are maybe active in the same field as you are, and check them out and see if they don't interfere with your intellectual property. So next slide, please. So like I said, we emphasize developing an IP strategy. In this picture next to, but in fact at the heart of your business strategy, where in your business strategy you determine the goal and vision of your company, and your IP strategy should involve being aware of your position relative to third-party intellectual property, and of course developing your own intellectual property and creating value using that position, either your own IP or using IP or using third-party IP. For example, if you have a license of a patent family from one of these institutions that I just mentioned, you can still create value using that. And a key factor in this whole process of developing your IP strategy is IP information. So we come to talk about that a little bit more later on in this presentation. So next slide, please. So here is again summarized. So a third-party IP is about having freedom to operate, or maybe licensing intellectual property, and above all, know the competition. And your IP rights, and preferably a portfolio, establish IP for new inventions. It involves, and I'm glad that Jono also mentioned this, it involves not only patents, but also trade names, trademarks, designs, copyright, and even other types of intellectual property rights may apply. And you have to manage it. You have to make sure that your IP portfolio fits your business strategy. If you abandon certain products, for example, see what you can do with your IP, which has a life cycle independent from your products. Perhaps you can sell it and make some more money out of it. Now, value creation. There are various ways of creating value from IP. Of course, we all know the exclusivity that arises from intellectual property, because an intellectual property right gives you an exclusive right on the exploitation of this knowledge, of the knowledge which underlies the right. In case of patents, you may forbid other companies to commercialize, for example, an invention. But of course, intellectual property rights give you the possibility to license out this right and make money by collecting fees from your licensees. Furthermore, you can trade with your intellectual property rights. You can exchange with other parties. You can participate in patent pools. And for investors, intellectual property rights, also like Jono and Frank already explained, can be considered assets for your company. And intellectual properties rights allow you to obtain finances from investors, and allow you to collaborate with other parties. So in the short term, there may be the other goals that you may have with your intellectual property. From my experience, on the short term, it's mostly about investments. On the long term, it's more about creating value for the company in terms of collaborations and obtaining royalty fees from licenses. Okay, next slide, please. So the third-party IP, this is about prejudicial or essential patents, trademarks, designs. And the questions that arise is, do I have freedom to operate? If there are prejudicial patents from other parties, you can also wonder if your freedom to operate is jeopardized. Can I work around this IP? Or do I need a license? Do I need to license in technology? And if not, you can wonder, can I invalidate this IP? So these are main questions in regarding this third-party IP. Next slide, please. Your IP portfolio, as we know, is about patents for technology, know-how. This may involve technology, trade secrets, market data, etc. Contracts, already seen in the former presentation. Trademarks, very often neglected, especially by SMEs and startups. Domain names. Of course, the domain name is not intellectual property right as such, but it's usually linked very closely to trademarks. Design rights can be very important if you develop products having a particular shape. Copyright. Well, we all know that software is about copyright, images, websites, manuals, etc. Next slide, please. So the value creation, like I mentioned, it can be done by exclusivity, licensing, collaboration, company value by means of financial assets. And it's a form of insurance to defend against claims from others. And there are many examples in our daily life, like, for example, the biscuits from Bolletje, having the recess in the biscuits itself, or for example, shape of and the pattern of a football, the DVD, the LEDs, all the underlying intellectual property has contributed to creating a huge amount of value for the holders of the intellectual property. Okay, next slide, please. Now, for deep tech startups who are at the very beginning of their existence, there's a great emphasis on technology. And the idea is that maybe there should be checked on novelty in not in a commercial sense, but in a technological sense. Is this novel idea really a contribution to the state of the art in technology? If so, then this could be patentable invention. And what is patentable? This can usually be discovered if this novel idea provides a solution to a known technical problem. And of course, if there is You check if the new features are not only technologically novel, but also commercially. Does the invention provide advantages over already existing solutions? And yeah, we'll have to look at cost of protection. Does it outweigh, or do the benefits outweigh the costs of protection? And also for startups, being not so much aware of the requirements for obtaining, for example, patent protection, keep your invention secret until you file a patent application, and plan the filing of your patent application. Don't do it too soon, and don't do it too late. If you're too late, the product may already be on the market, and then yeah, it's the patent application will be considered not novel. And usually you file for patent application when you have proof of concept. Okay, next slide, please. Yeah, so again, if you want to tell an audience at a presentation about your company, tell them about the results that you can achieve, but do not tell how you achieve the result. So don't disclose any technical details prematurely before you file a patent application. Okay, next slide. So now let's talk about patent protection a little bit more. I've been working as a patent attorney for many years, next to Laurens, in fact, in the last year. And I've had many entrepreneurs who come to me and wanting to file a patent application to obtain patent protection. Now, there is a misunderstanding with many entrepreneurs that they think that once you file your first patent application, you're done, and you have patent protection anywhere. Well, this is not the case, unfortunately, and it's quite a complex process, actually. So I'll in this slide and the next slide I show some details of that. But usually you start with a first filing or a priority filing, and this is usually a national patent application, for example, in the Netherlands. So before you file, like I said, and I can't emphasize it enough, keep it secret. After filing, in order to file your patent application, preferably go to a patent attorney who can help you do that. And once the application is filed, you will obtain a search report from my colleagues in The Hague. And the search report will tell you something about, first of all, other literature, and mostly patent literature, which may be relevant for your invention, concerning the novelty and inventive step of your invention. And it will have a written opinion from one of my colleagues who has been comparing the invention as claimed in the patent application with the literature that was found in the literature search. once you know what's in the search report and you have this opinion, after, or let's say within 1 year, you have the opportunity to file additional patent applications in other territories outside of the Netherlands for the same invention. So this search report may give you a clue whether or not you may have to do some alterations in what you actually lay down in your patent application. So there may be some amendments necessary, and then before the lapse of this first year, you can start, for example, an international phase, or also called a PCT procedure. PCT stands for Patent Cooperation Treaty. If you file an international patent application, this will be equivalent to national filing of a patent application in over 150 countries worldwide. Now, this is not yet the end of the story for your Dutch application. If the search report and the written opinion is really bad, and it turns out that your invention was already fully disclosed in other publications, then the question arises whether or not you may want to withdraw your application. And of course, at the same time, if it's already fully disclosed, then of course you don't invest in an international patent application. But if everything is okay, and you may have filed your patent applications outside the Netherlands, then your patent application will be published after 18 months after this very first date of your Dutch patent application. So this is a trade-off between the government and the entrepreneur, that you obtain exclusivity for your invention, but your invention is fully published, so it's available to the public from that date. And there's nothing you can do about that. You can request early publication if you want, but you cannot have your patent application published beyond this 18 months or 1.5 year time period. Okay, let's go to the next slide. Now, this first application, and the filing date of it, which is called a priority date, enables you to establish patent family, patent protection worldwide. And so if you followed the PCT procedure, let me say there are alternatives, but that leads too far to explain that all these alternatives. But if you follow the PCT procedure, you have an additional 1.5 years after filing it. So in total, 2.5 years before you are required to continue your international patent application in the territories or countries or regions where you want to have patent protection in the end. So in this example, USA was chosen, China, Japan, and EP. EP stands for European Patent. And that means that this is valid for countries that are contracting states of the European Patent Convention. And this is not the same as the European Union. In the European Patent Convention, for example, also Turkey is one of the contracting parties. So once you have entered this national phase, you will enter examination proceedings before the national offices. So this is something which is usually overlooked by many entrepreneurs because, well, let's say filing patent application is one thing, and it involves costs in the different stages. But the examination stage maybe also be quite a costly stage. Talking about costs, a first filing maybe in a range of 5 to 10,000 euros. Filing an international patent application maybe in a range of 5 to 6,000. And entering the national phase in USA, China, Japan, Europe may involve filing translations, for example, for China, Japan. And the costs will be also in the order of, let's say, 4,000 to 6,000 euros per country. So this is a costly stage, and this is usually a moment for an entrepreneur to consult with his investor. Are we going to invest in intellectual property in these countries? Now, once you've gone through the examination phase, usually, let's say in a range, some say 4 to 6, others say 5 to 7 years, but approximately in this range, the patent application may be granted, which is indicated by the green tick in the box. Of course, the application may also be refused, but let's assume that they're all granted. Then, for example, in Europe, for the European patent, you'll have to validate your European patent in the countries of your choice. So it may be that the European patent, you want to validate it again in the Netherlands because there have been some modifications relative to the very first Dutch patent application. And in this example, you validate in Germany, Great Britain, France, Italy, Spain, and hopefully next year we'll have a unitary patent which will be available for, at the moment, 13 states of the European Union. So you have a very large territory. And of course, in the end, the granted patent is also published. Okay. Are there at the moment intermediate questions, for example, about this granting procedure?
I was wondering. Oh no, I hear myself again. I was wondering if you don't vest your patent like internationally, do you then lose your rights on having a patent? Because when you ask for the PCT, then it's published, right? But if you don't do the extra vesting internationally, then it's in the world, but you can vest your rights anymore, right?
That is completely correct. So this is also a misunderstanding with many entrepreneurs, thinking that, well, I forgot to continue my patent application in I don't know, in Brazil, and I've had clients coming up to me and, well, can we file a patent application after all in this territory? And then the answer is no, unfortunately not, because the content of the application is already in the open, it's already published, so therefore it would be not novel. So this is not possible.
Okay. So it's smart to do it all when the PST phase is over.
Yes.
Yeah.
So the decision to file a patent application and start a patent family, the decision to go international, and the decision to continue your international application in the different countries, these are vital and strategic decisions that are to be made by the entrepreneur, and these are irreversible.
Yeah. Okay. Thank you.
Now, I have explained already in the beginning that patent information is vital, especially at the moment we're talking about, for example, patent families, etc. The decision to file can be supported by doing patent research yourself. So patent information helps you on the patentability of your inventions. If you do not yet have an invention, it may provide inspiration. If you want to endeavor in a certain field of technology, you may find existing solutions that may have been published in a patent application only. When I started working in the field of intellectual property in the 90s, I was told that of all inventions worldwide, 80% is published in a patent application only. So they may not be commercially available, but they can be. You can take knowledge of it through patent literature. And of course, from patent literature, it's all about patent applications and granted patents that have been filed and published already. You can find out, what third-party rights are there, which may be relevant for you. And of course, who are your competitors? And this may be surprising. And this is very important to establish this question of freedom to operate, which I already mentioned. But the patent literature may also help you find partners. If you know who is active in a certain field and with comparative technology, you may approach this competitor or third party for cooperation purposes, licensing, or maybe even an exit strategy. If your company has created value, you may find a partner, an acquisition partner who may buy either your IP or your company. And also from patent literature, you can find out what trends are there. If you, for example, are now considering investing in artificial intelligence, you'll find out that in the past 10 years, there is an exponential growth in number of patent applications about artificial intelligence. But you may also be active in a field where the number of patent applications are declining, and that may give you some information to be used for your marketing strategy. Okay, let's continue to the next slide. Patent information is disclosed in published patent applications. It has a lot of information. Already on the front page, you can find out the title. So usually this discloses the field of technology. It has an abstract. So you may learn about what the technology is about. All kinds of bibliographic data, dates, applicants, very important. Inventors may also be important. Classification codes. The technology disclosed in patent application is subdivided into technology classes, which may help you find the right literature. And I'll discuss an example of that later on. But there's also a more detailed information about the invention disclosed in this published patent application. So there is a detailed description. There are claims. The claims define in legal terms the scope of the invention that is claimed in this patent application. There may be drawings to support the description, and there may be a search report. So what we see here is an international patent application, and it's not always, but it may be accompanied by a search report, and if it's not there, it will be published in a later stage. But the search report is usually published simultaneously with the publication of the patent application itself. So you all also are able to get an idea of whether or not the invention that is disclosed in this patent application is novel or not. Okay, let's continue.
Arie, just for your information, we have still 5 minutes for left.
Okay.
Yeah.
So where do I find this information? You can find it in Espasnet, which is hosted by the European Patent Office, but there are other databases available, like Patent Scope from the WIPO or Google Patents, for example. Now, I think I've elaborated a little bit too much on the earlier slides, so I would propose to go to the not the very last page, but the one before the last page. The presentation can be made available for you. Yes, I wanted to show you the services that we provide. Yes, this one. The Netherlands Patent Office helps you using patent literature by and using intellectual property via workshops, webinars, well, presentations like this. We also provide expert hours where you can have an individual discussion about your situation, and we will point you to those who can give you proper legal advice. We can give you a search advice on how to search in patent literature. And we have orientational patent searches. So if you if you think, well, I want to know if your invention is novel or not, you can ask the Netherlands Patent Office to do a search for you, and you'll be provided with literature to make up your own mind on whether or not you want to enter and file a patent application. And we do this independently, confidentially, and free of charge. So let's go to the last slide then. Yeah, so these are some tips, but you can look them up later on. So if there are questions, I don't know if there is time for that, but otherwise, let's go to the last slide and where you find my contact details. So this concludes my presentation for today.